Foundation in international law. Begin with Article 16 of the ICCPR, which establishes the absolute right to recognition as a person before the law. This right is universally recognized, non-derogable, and fundamental to human dignity. Obligation to incorporate into domestic law. Highlight the obligation under the ICCPR for signatory states to incorporate absolute rights, such as Article 16, into their domestic legal system. This creates a binding duty to uphold and protect these rights within national frameworks. Prohibition of destructive action. Emphasize that under the ICCPR, states and their agents, including judges, are explicitly prohibited from taking actions aimed at the destruction or limitation of absolute rights. This prohibition reinforces the non-derogable nature of these rights. Evidence of domestic breach. Demonstrate how actions taken within domestic law, whether through judicial decisions or legislative measures, have been aimed at the destruction or limitation of the absolute right recognized in Article 16. Provide specific examples and evidence to substantiate this claim. Accountability for breaches. Argue that judges and state actors who knowingly or negligently take such destructive actions breach their obligations under both international and domestic law. Their actions undermine justice and the rule of law, warranting legal consequences. Higher standard of accountability. Reiterate that judges are held to a heightened standard of accountability due to their expertise and their critical role in upholding the principles of justice. Any violation of absolute rights reflects a serious dereliction of duty. Legal consequences. Conclude by calling for appropriate legal accountability, including potential criminal consequences for actions aimed at the destruction of absolute rights. This ensures adherence to international principles and maintains public trust in the judiciary. To align the actions or omissions of the Attorney General, Minister of Revenue, and Governor General or any other public or judicial officer with the relevant criminal code article. Neglect of duty, Section 122. This applies if they fail to act in the public's interest or fulfill their statutory obligations, especially where this neglect has led to a human rights violation or harm to individuals. Examples could include failing to prosecute clear cases of judicial misconduct, ignoring valid complaints, or failing to intervene when fundamental rights are being limited. Breach of trust, Section 122. If their actions, omissions, or decisions serve to benefit specific interests over the public or contravene their responsibilities, this can apply. For example, refusing to act on evidence of rights violations without a lawful justification, taking actions that undermine fundamental legal protections, such as Article 16 of the ICCPR. Obstruction of justice, Sections 139 to 140. This comes into play if they intentionally obstruct legal process. Examples include refusing to consent to prosecution in cases of judicial misconduct without proper reasoning, thus impeding accountability, deliberately allowing violations of fundamental justice principles to persist, intimidation or pressure, Section 423. If there is evidence that their conduct indirectly pressures individuals to conform to statutory recognition, despite absolute rights under ICCPR Article 16, this could be considered neglect of duty that automatically ties into this because they have a duty under law, under fundamental law, to respect the rule of law and not take actions aimed at the absolute right. They neglected their duty. Their duty under fundamental law requires them to uphold and respect absolute rights, such as those under ICCPR Article 16, and not to take or allow actions that undermine those rights. Period. At the core of our identity lies our natural personhood, an intrinsic status protected under international law. Article 16 of the International Covenant on Civil and Political Rights, ICCPR, guarantees the recognition of every person's legal personality, a protection that supersedes domestic laws. This recognition is absolute, unalterable, and non-negotiable. Furthermore, under Article 2 of the Covenant, member states, including Canada, are obligated to incorporate these protections into their domestic legal system. This means that our natural personhood and the rights that stem from it must be upheld as the foundation of all laws and governance. These protections ensure that statutory systems serve the individual, not the other way around, and that no government or institution can rightfully limit or abridge the recognition of our natural personhood. For example, being forced into statutory recognition, such as applying for a license or identifying as a corporate person, undermines the absolute nature of these rights and violates the principles of international law. When statutory systems overstep their purpose, requiring individuals to submit to constructs that conflict with their absolute rights, such as forcing statutory recognition or imposing undue limitations, they violate the very principles they were created to protect. It is through understanding this dynamic that individuals can recognize their authority and hold systems accountable. Every time a public official approaches an individual, they are using color of law from a statutory power, automatically assuming authority over the individual and claiming that a duty is owed to the statutory law. This operation of law is effectively placing limitations and abridgments on individuals' full legal capacity without a principle of fundamental justice and against the fundamental principles of justice as enumerated in Article 16 of the ICCPR, where recognition can never be forced. In fact, the actions of the public officer is directly attempting to remove the natural personhood and replace it with a statutory capacity. This is transpiring and coming forth as soon as any public agent interacts with you claiming you owe a duty to statutory power. It is a corrupted operation of law. The actors of the government, specifically public officers, police officers, and mayors, have the legal obligation to know this operation of law and never violate it. However, they violate it every time they force interaction with you. This violation is a direct assault upon absolute rights, for again, it is forcing you to enter into a role of a statutory creature without your consent and contrary to your natural personhood. Every time a public official approaches an individual, they do so under the color of law, operating from a position of statutory authority. In this interaction, they often assume automatic authority over the individual, claiming that a duty is owed to the statutory law. This assumption, however, fundamentally conflicts with the principles of natural personhood and the absolute rights protected under Article 16 of the ICCPR. Under this corrupted operation of law, public officers, including police officers, mayors, and other agents of the government, effectively impose limitations and abridgments on an individual's full legal capacity. These actions are taken without the principles of fundamental justice and in direct violation of the fundamental principles of justice as outlined in international law. Recognition of legal personality, our natural personhood, can never be forced. In these interactions, the public official attempts to strip away your natural personhood, replacing it with a statutory capacity. This happens the moment they claim you owe a duty to the statutory law, disregarding your inherent rights. Such acts are a direct assault on your absolute rights, as they force you into the role of a statutory creature without your consent, contrary to your natural personhood. What's crucial to understand is that public officers have a legal obligation to know this operation of law and to act within its limits. They are bound by their positions to never violate the rights of natural persons. Yet, these violations occur routinely when public officers force interactions and impose statutory obligations without consent. To assert your rights, it is essential to recognize and challenge these overreaches. By understanding your natural personhood and the obligation public officials are bound to, you can stand firm in your rights and demand accountability. It is not their role to dictate your capacity, but yours to remind them of the principles they are sworn to uphold. A judge is held to the standard of understanding what an absolute right is. They are expected to be well versed in the law, including principles like absolute rights, natural rights, and statutory rights. If they fail to uphold or recognize these principles, it can be considered a serious breach of their duty. If they breach the rule of law or a fundamental principle of justice, they can be held accountable, but within that context, right? That means they have to know what an absolute right is from the get-go. From the start of things, judges are required to know and understand what absolute rights are from the outset, as these are fundamental to the rule of law and principles of justice. Ignorance on their part is not an excuse, especially given their position. If they breach these rights knowingly or through gross negligence, it's a serious accountability issue. Well, if I'm bringing Article 16 of the ICCPR before them, right, and claiming that they're forcing recognition as a legal person, contrary to my natural personhood, Article 16 of the ICCPR guarantees recognition as a person before the law. And if they're forcing recognition contrary to your natural personhood, it challenges their adherence to international human rights standards. If they knowingly take actions aimed at destroying an absolute right, despite their obligation to understand and uphold it, they're in clear breach of their duty. Holding them to that higher standard reinforces the seriousness of their role in safeguarding justice. Judicial immunity protects judges from civil liability for their decisions, but it doesn't shield them from accountability under the criminal code. If a judge's actions amount to criminal misconduct, it's possible to pursue legal remedy. If a judge breaches the rule of law or fundamental principles of justice, Sections 119 and 131 of the Criminal Code of Canada apply. Section 119 addresses judicial corruption, while Section 131 deals with misleading justice.